Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have the docket for November 18th, 2021. First, Alec Murdaugh wants some civil cases dismissed against him. Second, Travis McMichael testifies in his own defense. How did that go? Kyle Rittenhouse jury continues day 3 of deliberation. Julius Jones, well, the governor allows him to live. Update on the Texas soup thrower. A professional athlete clearly didn't get the never hit a girl memo. A guy in New York, well, Christmas came early for him. The Malcolm X killers are cleared. Someone you don't want watching your children. And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk, the most fact-driven, unbiased, true crime channel. The channel where, that's right, me, your local criminal defense attorney with 26 years of experience, is going to explain the facts, the procedure, and the law regarding current and cold cases. Welcome to the show. All right, let's get going. If you haven't done so already, please hit that little subscribe button, hit that little bell so you receive notifications of when we go live or put up new content. Always leave me a comment below. And that's right, if you can't watch us here on Facebook or YouTube, you can go to any of your favorite podcasting apps. Simply type in Crime Talk with Scott Reich, and you can listen to not only this episode, but all of the previous episodes as well. And now a quick word from today's sponsor of the show, Home Title Lock. I'm excited to announce I am partnering with the #1 leader in home title protection, Home Title Lock. The county clerk won't call you if someone changes title on your home, and homeowner's insurance doesn't cover home title theft. Thieves can simply change ownership of your home from you to them. Then they take out loans on your home and just disappear. Anyone can be at risk of title fraud because your title information is public record. Home Title Lock will protect your home and assist you should any tampering or fraud occur during your active subscription. They offer 24/7 monitoring of your title and instant alerts if we detect tampering with your title or mortgage. Go to HometitleLock.com/CrimeTalk and use my code CrimeTalk to try out Home Title Lock risk-free for 30 days. That's HometitleLock.com/CrimeTalk and use my code CrimeTalk to try Home Title Lock risk-free for 30 days. All right, we are back. Let's start the docket for November 18th, 2021. First, Alex Murdaugh's defense attorneys, Dick Harpootlian and Jim Griffin, filed a shocking motion on Wednesday asking the court to dismiss the Gloria Satterfield lawsuit. Now, the attorneys are now representing the disgraced Alex Murdaugh in multiple criminal cases and lawsuits. And Satterfield's sons have settled with 5 parties connected to the botched wrongful death settlement since their attorneys filed a lawsuit in September. Now, Alex Murdaugh is the only remaining party in that case. And in the Satterfield case, Murdaugh and others are accused of making off with millions of dollars from a wrongful death settlement. Now, Murdaugh's latest charges stem from an investigation by the South Carolina attorneys Eric Bland and Ronald Richter, who uncovered a shocking paper trail showing how Alec Murdaugh allegedly stole $3.6 million from the Satterfield's settlement. After Miss Satterfield died, Murdaugh recruited his best friend Corey Fleming to sue him on behalf of her estate and convinced Gloria's son to sign over their personal representative rights to Westerndorf's so that the Flemings wouldn't be legally obligated to tell the Satterfield's family what was going on with the settlement. This is all according to Bland. Now, Murdaugh's attorneys argue in a motion to dismiss the suit that Gloria Satterfield's sons have been fully compensated for their alleged losses. Therefore, Alex Murdaugh, the alleged ringleader, should not have to pay any money back whatsoever. Well, Palmetto State Bank is the 5th potentially liable party to have settled or resolved differences with the Satterfield's family since Bland and Richter filed their lawsuits. the two attorneys have recovered more than $6.5 million in total for the Satterfield family, 2 months after Bland and Richter filed their lawsuit. Now, Harpootlian and Griffin filed a motion that claims Alex Murdaugh is entitled to a credit for more than the $6 million paid to all other settled tortfeasors. And this is interesting because now Alex Murdaugh confessed the judgment in lawsuits recently filed by his former law partner, John Parker, and his brother, Randy Murdaugh. This would essentially prioritize Alex's debts to Randy ahead of a line of alleged victims currently suing the man whose wife and son were killed in June. So now Alex Murdaugh is facing at least 6 lawsuits. 2 for the 2019 boat crash that killed Mallory Beach, 2 for millions of dollars misappropriated stolen funds dating back to 2015, and 2 for unpaid debts. Now, Murdaugh has only confessed judgment in Randy Murdaugh's case, according to court records. So the proposed remedies that the Murdaugh attorneys are seeking in the event the judge in this case has declined to throw the case out in its entirety, which they know isn't going to happen. There isn't a legal basis for tossing the case at this time. Their arguments are basically worthless. The criminal action is obviously brought by the state, so it's not the same action pending between the parties. Second, there's no right to a dismissal because a plaintiff has settled with a co-defendant. The jury would decide if the plaintiff's damages, what they truly are, and if that case, the jury could decide the actual damages sustained, which could be higher than what's actually been recovered to date. Particularly when you talk about the mental anguish and all the damages that had to come in the sense of having your money delayed, how that money could have been used more productively if it was invested. So there's still a money that can be sought by the plaintiffs against Murdaugh in those civil cases. And the court can't say that this case was worth a certain amount. That is a question of fact for the jury. So now, after many efforts in the defense of tossing the case, the attorneys for Murdaugh want it clearly as their primary argument. A stay in the civil lawsuit is the best interest of justice and judicial economy. The public interest will be best served by staying the civil lawsuit and allowing the criminal prosecution to proceed without interference. Now, this is not uncommon. Normally, when there is a civil suit and a companion criminal suit, obviously related and intertwined, the civil suit is stayed because the defendant still has a right to assert his Fifth Amendment privileges of self-incrimination. And so it makes no sense for the discovery and everything to go on while the criminal cases are still pending. So we'll see how that turns out. And that is an interesting argument that they're stating that, well, everybody else has settled, so just let me out. And they probably made more money than what they would have received, so let them out. We'll have to wait and see how that turns out. I don't think the court's going to dismiss the case. But you hear about that a lot in criminal cases, all right? A lot of people say, hey, I stole your car, which means I took it without legal permission or justification, and I gave it back, so what's the big deal, right? We see a lot of this now because motor vehicle thefts are, for lack of a better term, almost insignificant misdemeanors these days. And I don't know what rationale people think. Well, I took the car, I've just kind of borrowed it, the car's in good shape, maybe even washed it and put some gas in it. Well, no, that's not the whole point. The point under the law is that you took something without legal permission or justification of somebody else's stuff. You can't do that. So even if you did wash it, did put the car, back in a better spot, the point is you still took it initially without permission. Sometimes people get wrapped up about that. Well, why? The car's back, it wasn't damaged. No, it's the mere fact that you took it without permission. All right, let's move on to the Ahmaud Arbery trial. Travis McMichael, all right, defendant Travis McMichael, again, was on the witness stand Thursday morning under cross-examination regarding the 2020 shooting and killing of Ahmaud Arbery. Now, McMichael, one of the 3 defendants charged in the killing, was questioned Wednesday by defense and then the prosecuting attorney, and testified that he acted in self-defense as he and Arbery wrestled over McMichael's shotgun. Now, in early testimony Thursday, prosecutors pressed Travis McMichael over inconsistencies between parts of his description of the chase to the police to a couple hours after it happened, and his testimony about the pursuit in court. He said that he was scattered and mixed up after the shooting because this is the most traumatic event that he's ever been through in his entire life. McMichael also acknowledged several times under cross-examination that he never saw Arbery armed during the pursuit. Now, on Wednesday, McMichael testified that on the evening of February 11th, 2020, nearly 2 weeks before Arbery's shooting, he saw somebody creeping through the shadows in the neighborhood. And he testified the person, whom he later described to police as a black male, pulled up his shirt and went for his pocket in his waistband area. Now, Travis McMichael said he assumed the person was armed, so he fled in his vehicle as the person ran to a nearby home under construction. McMichael testified he told his father what happened, and the two went back to the unfinished home and called authorities. Police never saw or talked to the person Travis McMichael said he saw that night. Now, Travis McMichael then testified that he was sitting in his home on the day of the shooting when his father ran inside in a frantic state and told him to get his gun, saying the man from the days earlier had just run by the house and something happened. He was under the assumption that it was the same individual that he had seen at the unfinished house on the 11th, and he had previously had thought that something had been stolen from the site. Well, of course he thought something had been stolen, but he had no knowledge of anything being stolen. As you know, the owner of the site said nothing, in fact, was stolen. So Travis McMichael then said he grabbed his shotgun, and the defense attorney, Bob Rubin, said in opening statements 2 weeks ago that the person that Travis McMichael saw on February 11th was Arbery, verified by surveillance video, and that the encounter gave Travis McMichael the belief that on February 23rd that the person now running would be armed. Now, he testified he tried to ask Arbery while still in the truck what's going on, trying to de-escalate the entire situation. Now, he said Arbery did not respond and kept running. He testified he tried talking to Arbery a second time, during which Arbery stopped, did not say anything, but took off again after Travis McMichael said police were coming. Eventually, Travis McMichael said he noticed another truck in the neighborhood, and prosecutors contend Brian, the third defendant, got in his own truck and joined the pursuit, though he did not know what was going on, and then ultimately struck Arbery with his vehicle. Now, Arbery at one point seemed to be grabbing for the other truck, Travis testified, and eventually Travis McMichael said he parked his vehicle and saw Arbery coming in their direction and yelled at Arbery to stop where you're at, and went to grab his shotgun. At that point, Travis McMichael said Arbery turned and ran before eventually coming back again. Now, on the stand, McMichael's described Arbery as very angry and mad as the jogger got closer and focused on him. Now, as Arbery got closer, Travis McMichael said he drew his weapon on Arbery, according to McMichael's, and then Arbery darted to the right and later straightens up and starts running back straight to the truck where his father was at. The younger McMichael then testified he made his way to the front of the vehicle, and Arbery turns and is on me in a really quick, as he described it, is a flash. He grabs the shotgun, and I believe I was stuck on that first instance that we'd made contact. McMichael's testified, I shot him. Travis McMichael then said, his head lowered and his voice crackling, he had my gun. He struck me. It was obvious that he was attacking me, that if he would have got the shotgun from me, then this is a life or death situation, and that he's going to have to do something to stop him from shooting him, so he shot. Now, he didn't know where it was at, but he knew that he was on me, and I knew that I was losing him, according to McMichael. So he knew that he was being overpowered, and he didn't know which direction or what mechanics he was doing to overpower him, according to McMichael. And that's where he left off, and he was returning to the stand the next day. So obviously, as you can see, as we stress it all the time, it's always better for a defendant never to make any initial statements at the scene, because all those inconsistencies, well, they're brought up at trial, and it looks like you're tailoring your story now in court, and it goes directly to one's credibility. We'll see how the rest of that testimony continues and whether the other defendants are going to testify as well. And another self-defense case that we've all been talking about for the last couple of weeks, and I might note that, YouTube, if you mention the name, Rittenhouse might as well be the same as that guy named Jeff. They completely knock you out of the algorithms, and they say that your material is not suitable for audiences, at least anyone under the age of 18, even though we keep it pretty tame around here. Well, all right, let's move on. So day 3 of jurors in the Kyle Rittenhouse case, they're continuing to deliberate, and the judge has had to consider a couple of requests from the defense for a mistrial. As we mentioned yesterday, a key piece of evidence in the prosecution's case, this drone video that shows Rittenhouse shooting the man that he fired on the night of August 25th, was called into question Wednesday when Rittenhouse's defense lawyer said they received a lower quality version of the clip. Now, after jurors sent the question to the judge about how to view the video, the lawyers got into a very contentious debate over the key drone video. Defense attorneys called for a mistrial in the afternoon, saying the issue had to do with basic fairness and that they didn't realize that the clip was a lower quality until Friday when both sides were debating the jury instructions. The video in question is central to the state's claim that Rittenhouse provoked the attack, which would cast doubt over whether he could in fact claim self-defense. And prosecutors say that the video shows Rittenhouse raise his rifle at a couple who had been with Rosenbaum much of the night. That action, they say, provoked Rosenbaum to chase Rittenhouse, who shot the unarmed Rosenbaum 4 times after they had run across a car lot. Now, the defense said that's not what the video showed, adding that Rosenbaum had been acting aggressively and irrationally all night, threatening to kill Rittenhouse if he caught him alone. The video doesn't come into play in the trial until November 5th, when a former employee from the owner of the company that operated the drone dropped it off with the detective. Assistant District Attorney Krause said Wednesday, and at some point in the process shared the video with defense attorneys, and the file was somehow condensed, thereby lowering its quality. However, the district attorney cast doubt on the defense claim that they didn't have a high-quality version, saying that Rittenhouse's former attorney, John Pierce, had shared the drone video last year on Fox News with Tucker Carlson, and that the footage appeared to be of high resolution. Now, jurors were shown the clip during the trial and given a laptop that included it and other videos to review during the deliberations, and the judge also allowed them to watch on a large, high-resolution TV in the courtroom with everyone else locked out of the courtroom. Now, the judge has been very queasy, to use his words, about the drone video and expressed his concerns about whether it was technologically sound earlier in the trial. The judge on Wednesday allowed the jury to continue to view the evidence, but said the mistrial requests will have to be addressed if there is a guilty verdict. And if Rittenhouse is convicted, the judge could still grant the motion to dismiss with prejudice. And then obviously it would be an issue on appeal if the judge did not grant a mistrial. And then we had the most recent stuff. Boy, MSNBC News apparently has an independent journalist who maybe was stopped, that's right, for following the jurors on their bus, taking them back and forth from various locations. Poor decision. The judge was very concerned about it and basically banned MSNBC from the courtroom. More power to him. Now, nobody could say exactly what the intentions were or if they were threatening, but it's probably just a journalist trying to get the scoop on something and exercise some very poor judgment. But, do stupid things, you get stupid prizes. All right. A convicted felon with an open domestic violence charge has claimed to be the unidentified male at whom Kyle Rittenhouse shot twice at close range, but missed on the night of August 25th of 2020. Now, Rittenhouse has been charged with first-degree reckless and endangering safety of a man known in trial as Jump Kick Man for the flying kick he took at the teenager's head as Rittenhouse was attacked minutes after he shot Joseph Rosenbaum. Now, Maurice Freeland, 39, has admitted that he was the one who kicked Rittenhouse in the head and narrowly avoided being shot as a result. Now, moments after Anthony Huber swung at Rittenhouse with his skateboard for a second time, grabbing for the rifle that was slung across Rittenhouse's chest, Rittenhouse fired once, shooting Huber in the chest at point-blank range. Now it has emerged that the same is true of the jump kick man who was on board that night for an alleged assault on his girlfriend that included kicking her in the ribcage, having thrown her to the floor. And it's not known when the state learned of Freeland's identity, but it's been confirmed that he had wanted immunity before he would testify, and the DA would not grant the immunity. The man, Binger painted a hero, was out on bond, having been charged with battery, domestic abuse, criminal damage to property, domestic abuse, disorderly conduct, domestic abuse for the incident that took place on March 23rd. Police apparently responded to a call about a family trouble issue, and the police show up at the home of Maurice Freeland and his partner, Mona Lisa McDuffie. McDuffie said that she had been drinking and she took his keys so that he would not drive, and he became very angry. And then it's alleged that Maurice punched her in the chest 3 times, threw her to the ground, kicked her in the stomach, and punched the TV. She fled out the back door, heard him yell, "You better run, you bitch, I'll kill you." Maurice has several open cases against him and is currently an inmate at the Kenosha County Jail. Just kind of gives you an idea of the people that were out there protesting that night, doesn't it? Bunch of nice guys. And before you say, "Oh my God, Scott, you're being so biased," let's just note every one of the victims that was out there all have felony convictions. One was a registered sex offender released from a mental health facility, and the others have domestic abuse charges as well. So just bringing you the facts, ladies and gentlemen. You decide whether it's relevant or not, and obviously the jury's going to do that as well. All right, remember we brought you the story of Julius Jones yesterday, who was set to die today? Well, Oklahoma Governor Kevin Stitt has granted clemency to Julius Jones, commuting his death sentence just hours before he was scheduled to be executed for a 1999 murder that he says he did not commit. Now, Jones' sentence will be commuted to life in prison without the possibility of parole, and the governor said in the executive order that he issued this morning. Julius Jones was to be scheduled to be executed today at 4 p.m. Central Time, and Jones has been on death row for nearly 20 years in regards to the 1990 murder of a gentleman by the name of Paul Howell during a carjacking. Now, Jones says he's innocent, as does his family and his attorneys and his supporters. Mr. Howell's family remains convinced that Jones is in fact guilty. Jones' clemency petition says he's been on death row because of fundamental breakdowns in the system tasked with deciding his guilt, including ineffective and inexperienced defense attorneys, racial bias amongst his jury, and alleged prosecutorial misconduct. His case is over. He's exhausted all his other appeals, but he has now a life sentence without the possibility of parole. I guess congratulations to him. I'm sure that was a difficult decision for the governor, but the reality of it is he's the one that has the ultimate say right there at the very end. And he apparently thought there must have been some doubt or at least something that would make Mr. Jones worthy of staying alive, even though he will remain in custody for the rest of his life. All right, remember the story about the soup thrower that we brought you the other day? Well, got some updates for you. A Texas woman who allegedly threw soup into the face of a restaurant employee in an incident that went viral online has finally been arrested. Amanda Nicole Martinez was arrested and charged with assault causing bodily injury following the incidents at Sol de Jalisco in Temple on November 7th. Now, Martinez is alleged to have gotten into a verbal altercation with a staff member during a complaint about the soup that she had purchased. She claimed that the soup was too hot and had caused the plastic lid on top of the container to melt. Now, during the altercation about the food, Martinez is alleged to have picked up the soup and thrown it at the female employee's face. And Martinez was arrested and transported to the Bell County Jail Wednesday morning. And now, according to the Texas Penal Code, assaulting causing bodily injury is a Class A misdemeanor where a person found guilty of the charge faces up to 1 year in jail and a $4,000 fine. However, this could be a felony if, in fact, that hot soup caused some sort of permanent scarring or permanent disfigurement of the victim, which would obviously make it more severe punishment, a possibility including prison. I just don't understand why people need to assault people with food. Like, keep your hands to yourself, ladies and gentlemen. Didn't your parents teach you that? I'm sure they did. Don't touch. Keep your hands to yourself. Simple. Don't throw things at people. Well, here's a guy that didn't get the memo either. And the memo that he didn't get was, do not ever, ever, ever hit a girl, young lady, woman, whatever. Okay? Yeah. A former New York Jets running back is on video. And I'm telling you, the video, not good. Can't put it on YouTube, but we'll put up on our Patreon link. All right? Well, the video shows this ex-football player punching his girlfriend, or ex-girlfriend at this point, before tossing her into her TV at her Florida home, and is now on the run after his ex filed a restraining order and the police issued a warrant. So the home surveillance video shows Zach Stacy, he's 30, attacking the mother of his child in front of their 5-month-old son at her home in Florida. The footage was posted on social media by the victim, Kristen Evans, and Kristen has now filed for a protection order against Stacy, a former 5th-round pick who played in 8 games for the Jets in 2015. Now, the order claims that Stacy has been abusing her. The protection order alleged that Stacy had been abusing her since she was pregnant with her son, with the attacks escalating and no signs of stopping. She also revealed that Stacy was voluntarily hospitalized for mental illness in March of 2021 and is taking medication for his issues. Now, Evans can be heard begging for Stacy to stop in the video, and Evans claimed on social media Wednesday that Stacy is still on the loose in Nashville, in the Nashville area, and that the officers in the town of Oakland, where she lives, took 4 days to actually get a warrant issued. Now, Kristen Evans claims that the officers that came to her house didn't seem to think that this was a bad enough incident to make an immediate arrest or to file for an immediate warrant. According to the victim, it took 4 days of her calling people and the Orange County officer speaking on her behalf. Now, Evans wrote in her restraining order application, "He punched me several times in the head. I begged him to stop because the baby was on the couch just a few feet from where he punched me. He then picked me up and threw me into my TV. The TV began to fall, and he turned to make sure I wasn't getting up." She alleges that as she laid on the floor, he began to yell at her, telling her, "I'm destructive." He then picked me up off the floor and on his feet and slammed me into our son's bouncy seat. Evans says she fears for her life and her children's life. She added that the assault has occurred several times on August 15th because he wanted money back that he had given Evans for rent. In that incident, Evans says Stacy punched her legs, slapped her, and picked her up and threw her into a window, which broke. Now, Stacy's violence, according to the restraining order, extends back to the weeks before their son was born. And Evans has expressed her outrage at the police on social media, saying that the Florida justice system is failing her. She said other women fall victim to this every day and urges people to call the attorney general. Now, ladies and gentlemen, we can't put the video up, but it clearly shows somebody with some serious anger issues, and the protection order rightfully should have been granted in this particular situation. Nobody should have to take this type of abuse from anyone. And if you know somebody does, try to help them out. This is just not right at all in any way. And, this goes back to, we've joked about it before, the Reich law firm rules of dating. Always check the medicine cabinet, right? And if someone is on medications, mental health, for example, probably during the course of that relationship, somebody's going to jail. Just saying, seen it too many times over the years. All right, this next story is probably going to get you fired up, and it probably should. All right. The defendant in this case, let's just say Christmas came a little early for him. Victims were visibly upset in court, crying, and one even reportedly vomited as a 20-year-old New York man who pled guilty to assaulting 4 teenage girls with a sexual factual basis inside his parents' home was sentenced to no jail time and instead received 8 years of probation. Now, the Niagara County Court Judge Matthew J. Murphy III told Christopher Belter on Tuesday that prison time would be inappropriate and instead ordered him to register as a sex offender instead. Now, Belter could have been facing up to 8 years in prison for his crimes. Well, Belter, it's alleged, he pled guilty, assaulted his 4 victims between February of 2017 and 2018, with 3 aged 16 and 1 aged 15 at the time of the assaults at his parents' house and house parties. Now, this was in a wealthy neighborhood. Police claimed that the 20-year-old mother, Tricia Vacanti, 50, stepfather Gary Sulo, 56, and family friend Jessica Long allegedly groomed the 4 victims by supplying alcohol and marijuana. Belter had pled guilty to felony charges, including third-degree rape and attempted first-degree sexual abuse, and 2 misdemeanor charges of second-degree abuse with a factual basis for sex. Belter's mother, stepfather, and family friend all pled not guilty to charges of child endangerment and unlawful dealing with a child. Judge Murphy told Belter that his 8 years probation would be like a sword hanging over your head for the next 8 years. I agonize, I'm not ashamed to say, that I actually prayed over what is the appropriate sentence in this case because there was great pain. There was great harm. There were multiple crimes committed in this case, according to the judge who said this in the shocked courtroom. It seems to me that a sentence that involves incarceration or partial incarceration isn't appropriate, so I'm going to sentence you to probation. Judge Murphy did not offer any further explanation for his decision not to impose jail time for Belter. Now, prior to his sentencing, Belter addressed the courtroom to reveal his deep shame and regret for his actions, and he said, quote, "I hope each of you can close the wound that I gashed, and I know, though, that the scar will remain that will serve as a reminder of the evil of that night." Belter will appear again in court on December 3rd so that the ruling can be made on what level a sex offender he will be classified as for the next coming years. Couple things about this case, ladies and gentlemen, and I don't know why it is. People think it's cute. People think it's funny to provide alcohol to your kids for a house party. Okay? It's against the law. You are contributing to delinquency of a minor. They may call it something under other cases, but that's what it is. Contributing to delinquency of a minor. It's a felony. Do you really think your child having such a good time is worth a felony? Now you think, oh, that's okay. My parents used to buy me beer and we used to have parties all the time. Okay? Life has changed. The world has changed. This stuff comes out, and guess what? If somebody got hurt, in this particular case, sexually assaulted, and if somebody died, all those parents are going to jail. The parents still face charges. I get it. People want to be the cool parent. Listen, you're supposed to be a parent, not your kid's best friend. Don't supply them drugs and alcohol. It's that simple. Let's talk about the Malcolm X, okay? So Muhammad A. Aziz and Kaleem Islam, 2 of the men found guilty of the assassination of Malcolm X, are expected to have their convictions thrown out after spending more than 20 years in prison. Now, a 22-month investigation conducted by the Manhattan District Attorney's Office and lawyers for 2 of the men found that prosecutors and 2 of the nation's premier law enforcement agencies, the Federal Bureau of Investigation and the New York Police Department, had withheld key evidence that, had it been turned over, would likely have led to the men's acquittal. I'm shocked. I am shocked. The government not revealing exculpatory information? Oh my goodness, tell me this doesn't happen. Well, the review reveals that the 2 men were themselves victims of the very discrimination and injustice that Malcolm X denounced in his language that echoed across the decades, Muhammad Abdul Halim, a member of the New Jersey chapter of the Nation of Islam, who confessed to the murder in trial and whose guilt and conviction stands, has maintained that the other two men were innocent. Now, the Manhattan District Attorney, Cyrus Vance Jr., apologized on behalf of law enforcement, which he said had failed the families of the two men. Now, Vance's re-investigation conducted with the Innocence Project and the Office of David Shanise, a civil rights lawyer, contended with the facts that many of the witnesses, investigators, and trial lawyers are now dead, the loss of key documents to time, and the inability to test physical evidence that was no longer available. However, significant FBI documents included information that implicated other suspects and pointed away from Islam and Mr. Aziz. Prosecutors' notes indicate they failed to disclose the presence of undercover officers in the ballroom at the time of the shooting. And police department files revealed that a report to New York Daily News received a call the morning of the shooting indicating that Malcolm X would be murdered. Now, altogether, the reinvestigation found that had the new evidence been presented to a jury, it may have well led to an acquittal. One of the most significant weaknesses in the government's case, the review found, was Halim's confession and his assertion that his co-defendants were innocent. The exonerations are long overdue, according to Brian Stevenson, a civil rights lawyer and the founder of the Equal Justice Initiative. This is one of the most prominent figures of the 20th century who commanded enormous attention and respect, and yet our system failed. That's right, ladies and gentlemen. I guess it makes you wonder, at what point do you just lose complete faith and trust in our government and law enforcement agencies? Now, are there good guys in the agencies? Yes, they are, but you know, we've talked about this before. If the good guys don't stand up and say what the bad guys are doing, they're just as bad as the bad guys are trying to prosecute. In this particular case, people spent decades in prison for a crime they didn't commit, and the government knowingly withheld evidence that would have set them free. At what point do you come to the conclusion that you cannot trust your government, right? You have to trust but verify. I don't know. When you hear about cases like that, it really makes you wonder. When I was a younger man, I just trusted everybody. Maybe I'm just getting a little more cynical as I get older, but the reality of it is, it really makes you wonder if you can really trust anybody. And agencies that you thought were beyond reproach, the FBI, apparently not so much. I mean, we knew about Herbert Hoover, but geez, now it's modern day stuff. All right. Hey, let's talk about a woman you don't want taking care of your children. A Michigan woman has been stripped of her daycare license after she allegedly put a child and another youngster into a clothes dryer and turned it on. Kathleen Mahay Radabach, who ran an in-home daycare at Garden City at her residence, took the alleged aggressor, described only as a minor household member, to hospital on August 4th because the juvenile was stressed out after putting another child into the dryer. The child admitted to a nurse and at a social worker that she put the unidentified girl in the machine and turned it on. The girl said that Kathleen Mayhew Radabach got her out of the appliance before she was seriously injured, but the woman did not tell her mother about the frightening incident. Now, Mayhew Radabach also lied to investigators and denied that the child put another juvenile in her care into the appliance. The investigation determined that Mayhew Radabach provided a lack of appropriate care and supervision and failed to provide truthful information to the state officials. She also failed to tell regulators the minor who put the girl into the dryer was hospitalized in January while receiving mental health treatment. A summary suspension order with the intent to revoke the license bars Mayhew Radabach from operating a family care child home center in Garden City or anywhere as of November 3rd. I agree. Now, we've all been parents and kids have done some things, but when you're being paid to watch other people's kids, you better be careful. All right, finally, our dumb criminal of the day. Crime Talk's dumb criminal of the day. A Florida man was arrested after setting fire to a memorial for the victims of the 2016 Pulse nightclub mass shooting. Mark Henson, 64, was charged with felony criminal mischief in connection to the fire. A surveillance video shows a man in a wheelchair igniting the offering wall, which was created to honor the lives of the 49 people killed in the shooting. 3 angel banners were burned along with other items within the affected area, according to the foundation. No motive for the fire was immediately provided.